Preventive detention laws in India have a great potential to be abused and misused. This was an observation made by Honorable Supreme Court in Pramod Singla versus Union of India in the year 2023. Hi, I welcome all of you to today's session on preventive detention. Preventive detention is a detention without trial, and it is so called in order to differentiate it from punitive detention. The object of punitive detention is to punish a person who has committed some illegal act or who has committed some offense. Whereas on the other hand, the object of preventive detention is to prevent him from doing something. In such a case, a person is detained on the apprehension that he was going to do something which would have been covered by any of the specific grounds mentioned in our constitution. Which article specifically? Article 22. Article 22 of our constitution deals with two very important aspects. Firstly, it deals with persons arrested under ordinary law of crimes. Secondly, it deals with detentions, the persons detained under the laws of preventive detention. The first two clauses of Article 22, if we'll read Article 22 from the Constitution, you'll find that first two clauses of Article 22 are dedicated to the cases in which arrest happened under ordinary law of crimes and what procedure should be followed in such cases. Then the rest of Article 22 is dedicated to preventive detentions, and it grants power to the legislature to enact laws on this subject and also lay down certain safeguards to prevent abuse of such power by the state. So the latter part, clause 3 onwards, Article 22 can be further divided into two categories. One is the legislative power of the state and the other is the safeguards that are required to be followed. And it is because of these safeguards that preventive detention actually finds a place in our constitution. And it is actually these safeguards which are fundamental rights. See, preventive detention has a long standing history in India. It started with the third Bengal regulation in the year 1818. And then we had Rule 26 under the Defense of India Act 1939, which was a war specific measure, and it was modeled after a similar on a similar legislation in England during the wartime, during the Second World War, but the same continued even after cessation of war. And the framers of our constitution thought to continue with it because they were of the opinion that the situations which actually necessitated such laws to be in place, they did not completely vanish after India attained independence. And um, but they remodeled it, and certain improvements were made in the existing law. And now what we see is a combination of preventive detention law, which allows you to detain uh, persons for the purpose of preventing something. At the same time, there are certain safeguards that are required to be respected. So there was an improvement, and um because of this improvement, we are able to keep the powers of the state in check. There are sort of checks and balances on the arbitrary exercise on the power on the exercise of power of the state, so that there should not be arbitrary exercise of the same, right? So with this, now I think we can move on to certain specific areas related to preventive detention, which are important from examination point of view and even otherwise to appreciate completely this particular area of law. The first aspect is the scope of Article 22 itself. The earlier view was that Article 22 is a complete exhaustive code on with respect to preventive detention. It was in A.K. Gopalan versus State of Madras, AIR 1950 Supreme Court 27. It was held that a person who is detained under any preventive detention law cannot claim freedoms that are available under Article 19 of our Constitution. It was also held that a person under preventive detention cannot claim violation of personal liberty, which is being talked about under Article 21 of our Constitution. But this view was later on changed in subsequent cases. R.C. Cooper versus Union of India, AIR 1970 Supreme Court, 564. And then all of us know this, a celebrated case of Maneka Gandhi versus Union of India, AIR 1978 Supreme Court, 597. Now, as per this later view, it was held that preventive detention laws have to satisfy the requirements of Article 21 as well, apart from being in line with Article 22, the safeguards. Right? So, if legislature comes up with a law on preventive detention, it is not only Article 22 that needs to be satisfied. It is also Article 21, which means the procedure prescribed by such a law has to be just, fair, and reasonable. It has to satisfy the requirements of Article 14, 19, and 21 as well. So this is the scope of Article 22 now. The next aspect relating to preventive detention is the nature of preventive detention. What is the nature of preventive detention? Whether a person under preventive detention surrenders all the rights, all the freedoms, or does it have a limited application? What is the exact nature? So the nature of preventive detention was highlighted by Honorable Justice Subbarao in the case of State of Maharashtra versus Prabhakar Sansgiri, AIR 1966 Supreme Court 424. In this case, Prabhakar was detained under Defense of India Rules 1962. And when he was under detention, he wrote a book titled Inside the Atom. This book had nothing to do with security of India. It did not pose any danger to the public safety as well. But when permission was sought to send out the copy of the book, the copy of the manuscript, in order to have it published, the same was refused. And the justification for refusal was that when a person is under preventive detention, he or she surrenders all the freedoms, and he or she can enjoy only such privileges which are expressly mentioned in the order of preventive detention. But Justice Subbarao brushed aside this argument, and he held that though a person under preventive detention in a way has forfeited his right to move freely, but the other freedoms will be available to such a person. And the freedom to write a book and get it published is one such freedom which will be available. So regarding this, late Fali Nariman sir has written in his latest book, You Must Know Your Constitution. It is behind me, in the one in the black cover. You must know your constitution. He says that the Subbarao court turned the state argument on its head. And if such an argument would have been accepted, this would mean that the person under detention could be starved to death if the detention order does not specifically provide that the person needs to be provided with food. Right? So absurdity was pointed out. So consequently, the court was of the opinion that refusal was not in accordance with law. Then the next aspect that we should discuss is the approach of courts in such matters, in the matters related to preventive detention. What should be the approach of the courts? In Pramod Singla versus Union of India, to which I referred in the very beginning, it was held that in the matters under preventive detention laws, when a person is under preventive detention and when the constitutionality is also challenged, then the courts must be very cautious because it is a matter of liberty of the person. It has to be cautious and ensure that checks and balances of the power of the on the government must be maintained. It was also held that any doubt will go in the benefit of the detainee, the person detained. And even the slightest of errors in procedural compliances will again go in the benefit of the detainee. Right? Because as I have said, that it is a matter of personal liberty. Then the last thing that I would like to discuss with you is not the second last thing, last one as per my notes, but I will discuss one more thing with you before ending today's session. So the second last thing is the power to grant damages. The issue is, can the court, which set aside an order of preventive detention, can it order damages in favor of the detainee? So a Madras High Court judgment we have here, Sunita versus Additional Chief Secretary to Government 2022, right? So in this case, Madras High Court, while quashing a detention order, has held that if it was based on irrational considerations or irrelevant or non-existent considerations or grounds, then the state should be made liable and state should be asked to pay damages in such situations. Right? And as I have said that there is one more thing that I wanted to discuss with you or rather highlight it for you for the purpose of examination. Sometimes in examination, they ask you question based on a landmark judgment. It is very important judgment as far as preventive detention is concerned. It is A.K. Roy versus Union of India. And the same judgment is also a landmark judgment on the aspect of the lawmaking power of the executive, the ordinance. So I'll giving you a kind of homework on your part that please go through the guidelines. They are very interesting guidelines, though A.K. Roy is a judgment which needs to be discussed in a separate session, but at least you can go through the guidelines. Sometimes in the examination in prelims, they ask you a direct question that which one of the following judgments is the landmark judgment on preventive detention, and you'll find A.K. Roy mentioned in the options. And then a subjective question can also be asked from this area, specifically asking you the guidelines. And even if question is not specifically based on A.K. Roy, you must make A.K. Roy guidelines part of your answers. And if your interview gets interesting, especially in states where constitution is one of the subjects, then the board members can also pose this in the form of question. Right? With that, I end today's session. And if you found this interesting, Please do share, like, and subscribe, and I'll see you in the next one.